All right. So, prosecutor, we ready to call our next witness?
Yes, sir. The state calls Lazaro Cardenas.
Okay. So just watch your step. If you could just put your left hand on the Bible and raise your right hand for me. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Once you sit down and you're comfortable, can you state your full name for the record and spell your last name, please?
Lazaro Cardenas, Cardenas.
All right. Thank you so much. Prosecutor, when you're ready.
Thank you. Good morning, sir.
Good morning.
Can you tell us what you do for a living?
I'm a chosen state's attorney.
Okay. Are you licensed to practice law in the state of New Jersey?
I am.
Okay. Any other states?
No.
Now, before we get too far into this, I just want to ask the court for permission to approach.
You can.
Just show it. 24 for identification. Sir, I'm going to ask you, do you recognize what that is?
Yes.
And what is it?
It's my CV, my resume.
Okay. CV, resume, two different ways to say the same thing?
Mm-hmm.
Okay. Now, does that document your work experience?
Yes.
Does it document your education,
Yes.
both in the legal field and also previous to that?
Correct.
Okay. And does it fairly and accurately capture, your career, specifically your work career and your education?
Yes.
Okay. Now, can I ask you, what year did you graduate law school?
Rutgers Law in Newark.
What year?
2013.
Now, did you have any work experience prior to going to law school?
Yes.
And what was that generally?
I was working at Prudential Insurance for the prior and during law school for 18 plus years.
Okay. Now, your experience at Prudential, did that relate to what you do now for a living?
It really doesn't.
Okay. What did you do at Prudential?
At Prudential, I was in corporate technologies. I was a director of technologies.
Okay. When you started at Prudential, did you have a college degree?
I did not.
Okay. Was there a point in time that you decided to further your education?
Yes, a few years into my life at Prudential, I decided to go back to college.
And where did you go to college?
Went to Brookdale first, and then Rutgers Newark undergrad.
Okay. What year did you graduate?
2008.
And what kind of degree did you get?
I have a degree in business and a degree in political science.
Now, once you graduated college, did you continue to work at Prudential?
I did.
Now, how long did you work at Prudential or continue to work at Prudential until you decided that you might want to pursue a career in law?
About 4 years.
Okay. And how did you go about applying to law school?
So once I graduated from undergrad, I already had an idea I wanted to go to law school. So I had applied to law school during my last year at Rutgers undergrad, and then decided to go to law school. So I had applied, taken the LSAT, and just delayed the admission for a year until 2009.
Okay. So when did you start law school?
2009.
Okay. And what type of program did you do at law school? Was it traditional 3-year, or was it something else?
No, it's an evening program, which it's 4 years.
Okay. And did you continue to work while you went to law school?
I did.
Okay. And Prudential's where?
Prudential is about a block and a half, 2 blocks from law school.
Okay. They're both in what city?
Newark.
Okay. Now, as a result of the 4 years of study at Rutgers Law School in Newark, did you ultimately obtain a degree?
Yes.
Okay. And what type of degree is that? Just so we understand.
Juris Doctor.
Did you have to thereafter take and pass a bar exam?
Yes, I did.
Okay. And did you pass the New Jersey bar exam?
Yes, I did.
Okay. Now, did you start practicing law right away?
I didn't start practicing law right away after I finished law school, no.
Did you continue to work at Prudential?
I did.
Okay. At some point thereafter, did you do anything in furtherance of working as an attorney?
So yeah, my partner and I decided to open our own law practice, which is why it took us a little longer. We were trying to establish our finances before we jumped out of our full-time jobs.
Okay. And ultimately, did you establish a law practice?
We did,
And when was that?
2017.
Okay. And since 2017, have you continuously practiced law
Yes,
in the state of New Jersey?
yes.
Okay. And the name of your law firm is what?
Patel and Cardenas LLC.
Okay. And do you have one office or more than one office?
We have two offices, one here in Freehold Borough and one in Jersey City.
Now, how many attorneys practice there, to be clear?
We have 3 attorneys, including myself, and 5 paralegals.
Okay. Now, do you have a specific role in the firm?
Yes,
What's that?
I'm the managing partner for trust and estates and probate.
Okay. What does that entail, being the managing partner?
That entails getting involved with the day-to-day operations, managing the attorneys and paralegals in the team, and getting involved in the litigation that's held or that's going on with cases.
Now, on your CV that you described earlier, I believe it's S24 in front of you, is that correct? Does that document the type of work that you do on a daily basis?
Yes,
And do you talk about on that CV your areas of trust and estate practice?
yes.
Okay, and did you divide it up into kind of like 2 subcategories?
I did.
And what are those?
So that's trust law and administration and estate planning and probate.
Can you first just tell us a little bit about what trust law and administration is and how you practice in that regard?
So trust law and administration has to do with the creation of the trust and assisting people in understanding whether they need it or not, depending on if they need it, and assisting them in creating that trust that is going to reflect what they want to happen to their assets after they pass or even during their lifetime.
Before I ask you what a trust is when someone comes in and attempts to retain you as an attorney in this area, is their intent something that's important to you?
Absolutely. It's almost the first thing that's important.
Now, you talked about a trust. Can you just tell us, first of all, kind of generally what a trust is legally?
So trust is a legal entity where a trustor, the person creating it, transfer assets for the benefit of the beneficiaries that he would like to benefit from those assets, either during their lifetime or after death.
Now, have you been involved in establishing trusts for clients in the past?
Yes, I have.
Did you approximate how many times?
Dozens, if not hundreds.
Now, you also talked about estate planning and probate. Can you tell us what that entails?
Yes, estate planning encompasses a lot more than trust. Trust is one component of an estate plan. So typically we meet with the client, we ascertain what assets they have and how do they want those assets to pass to their heirs. And probate is the court-supervised process of transferring assets once a person passes.
So, fair to say trust, planning and trust creation is a part of overall estate planning?
Yes.
Are there many facets to estate planning?
Yeah, there are multiple documents that get created during estate planning.
What types of documents?
This could be a will, power of attorney, healthcare directive,
Okay. And is sometimes a trust a part of
trust,
something that gets created?
revocable or irrevocable trust, multiple different trusts.
You talked about revocable and irrevocable trusts. Can you tell us what those are and how they might be different?
So a revocable trust, the trustor, the person creating the trust, maintains controls of the assets and usually is the trustee of the trust and sometimes even the beneficiary of the trust. In an irrevocable trust, the trustor relinquishes that control to a third-party trustee, typically a family member, but it could be an entity as well that could manage those assets that are in the trust for the beneficiary of the beneficiaries, for the benefit of the beneficiaries.
Now, based upon your work as an attorney who practices with estate planning and trust creation and the like, are there like typically reasons why someone would decide upon, or you would assist them with deciding upon a revocable trust versus an irrevocable trust, age, other factors?
Yes, typically people do a revocable trust to avoid probate is one of the reasons they do it, to create a form for multiple beneficiaries to continue to operate or own those assets beyond the death of the trustor. Irrevocable trust, often done for tax planning purposes, for Medicaid planning purposes, and it's also done to reduce the taxable estate of the trustor when they die.
Now, you talked a little bit about tax implications, correct?
Yes.
Is that something that plays an important role in estate planning?
Yes, absolutely.
Now, are you an accountant?
I am not, and we do not do tax advice, but we work closely with tax professionals.
Okay, so is it fair to say that your practice can sometimes be collaborative?
Yes.
And does that, I guess you've already said, that includes tax professionals? Is that a yes?
Yes. Yes, that's a yes.
Just for the record. Does that also include any other, like, professional advisors?
Yes, so we work closely with either accountants, CPAs, financial planners. We often meet with them because our clients ask us to in creating an estate plan.
Okay. Are there times when someone might come to you without an accountant or without a financial advisor, and you would then suggest involving those types of professionals in the process?
Yes.
Now, just for purposes of the record, over the course of your legal career, you mentioned wills. Have you drafted wills?
Yes.
Could you approximately how many you've drafted?
Of wills.
Excuse me?
Hundreds of wills.
Okay. Now, power of attorney documents. Have you been engaged in creating those?
Yes.
And again, just so we understand, what's the purpose of a power of attorney document?
Power of attorney gives a person the ability to represent you in financial matters and court matters should you become incapacitated, but you're not dead.
Now, have you engaged over the course of the last, 8 or so years in overall comprehensive estate planning for clients?
Yes.
And that includes, you said, trust, correct?
Yes.
And have you created for clients both revocable and irrevocable trusts?
I have.
Okay. Now, have you ever been engaged by clients who already have wills or already have trusts, and they're looking for advice for a variety of aspects?
Yes, sometimes people want to update their will. There's life-changing events that prompt that. Trust, sometimes they want to change beneficiaries, or they want to change trustee or update it in certain matters, so modifications or
Now,
often.
you mentioned changing a trustee in a trust, correct?
Yes.
Now, is that something that can happen both with revocable trusts and irrevocable trusts?
Yes, it's much simpler to do with a revocable than irrevocable. Both can be modified, yes.
So it's more difficult when we're talking about an irrevocable trust.
Yes.
And we'll talk about that later, but in this case, you were asked to look at a trust, correct?
Yes,
And that was one that you did not create, correct?
correct.
And what type of trust was that?
It's an irrevocable trust.
So that would have been the more difficult kind to change the trustee.
Yes.
Judge, at this time, the state would offer Mr. Cardenas as an expert in the field of trust law and administration, as well as estate planning and probate.
Any voir dire on this?
No, Judge, we're satisfied with Mr. Cardenas' experience and expertise.
Okay. Ladies and gentlemen, I gave you this charge before. I'm going to give it to you, though, again. As a general rule, witnesses can only testify to facts known by them. This rule ordinarily does not permit to be received as evidence the opinion of a witness who is not testifying as an expert. However, an exception to this rule exists in the case of an expert witness who may give their opinion as to any matter in which they are versed, which is material to this case. In legal terminology, an expert witness is a witness who has some special knowledge, skill, experience, or training that is not possessed by the ordinary juror, and who thus may be able to provide assistance to you in understanding the evidence presented and determining the facts in this case. You are not bound by such expert's opinion, but you should consider each opinion and give it the weight to which you deem it is entitled, whether that be great or slight, or you may reject it. In examining this opinion, you may consider the reasons given for it, if any, and you may also consider the qualifications and credibility of this expert. It is always within the special function of the jury to determine whether the facts on which the answer or testimony of this expert is based actually exists. The value or weight of the opinion of the expert is dependent upon and is no stronger than the facts on which it is based. In other words, the probative value of the opinion will depend upon whether, from all of the evidence in the case, you find that those facts are true. You may, in fact, determine from the evidence in this case that the facts that form the basis of the opinion are true, are not true, or are true in only part. And in light of such findings, you should decide what effect such determination has upon the weight to be given to the opinion of the expert. Your acceptance or rejection of the expert's opinion will depend, therefore, to some extent on your findings as to the truth of the facts relied upon. You, and you alone, are the sole fact finders in this case. You must be persuaded solely by the evidence presented at trial when determining whether the state has satisfied its burden. As the sole judges of the facts, you are to determine the credibility of the various witnesses, as well as the weight to be afforded to their testimony to determine whether the state has proven beyond a reasonable doubt all of the crimes charged. Everybody understand that charge?
Yes.
Thank you. He is now qualified in the field of trust law and administration and estate planning and probate. Go ahead.
Thank you, Judge. Mr. Cardenas, I wanted to ask you a little bit about what specifically you were asked to do in this case, okay?
Yes, I was given a irrevocable trust to analyze and provide guidance as to the law and trust in New Jersey.
Okay. Now, as a result of that, we'll probably get there in a moment, but were you provided with a physical, actual trust agreement?
Yes, electronically.
Okay. Now, were you provided with significant factual details about this case?
I was not.
Okay. Now, as you said, your purpose was to take a look at the trust and provide some guidance as to what certain things mean in it, correct?
Yes.
Now, I'm going to just approach with S26. Do you recognize that?
Yes.
And what is that?
It's a Keith Caneiro irrevocable trust agreement.
And was that the document that you were provided with in
Yes.
order to analyze it?
Yes, it was.
Now, before we go any further, can you tell us what the date is of that document?
Yes, created July 27th, 1999.
Okay. Now, as a result of your review of that trust agreement, did you ultimately prepare a report regarding the document?
Yes, I did.
Okay. I'm going to approach again.
Okay.
Just going to show you what's been marked as S25 for identification. Do you recognize that?
I do.
And what is it?
This is the 24-page report I created once I analyzed the trust.
Okay. And like you said, that's a document that you created, correct?
Yes.
And what's the date of that?
That is July 28th, 2025.
Okay. Now, I'm going to leave that up here, but I would just say if you do need to refer to it at any point, just in case, just please indicate that you would need to refer to that so we know, right?
Yes.
Now, we talked about previously what a trust is, so I'm not going to ask you that specifically. I think you explained it. You mentioned earlier terms like, you said settler or trustor. What does that mean?
Settler or trustor is the person that creates the trust.
Okay. And does the trust ultimately have something called a trustee?
Yes.
And what is a trustee?
Trustee is the person charged with managing the assets in the trust for the benefit of the beneficiaries.
And based upon your review of this particular trust that was created in 1999, who was the settler or the trustor of this?
It was Keith Caneiro.
Okay. And who was the trustee designated in the trust agreement?
The primary was Paul Caneiro.
Now, the document, the trust agreement, which I provided to you, which is S-26, correct? The actual trust agreement?
Yes.
It's S-26, right?
Yes, it is.
Okay. Now, was that document signed by anyone?
Yes.
And who was it signed by?
It was signed by the trustor, the creator, and also by the trustee.
Okay, no, that would be which people?
So signed by Keith Caneiro and Paul Caneiro.
Okay. Now, was it like notarized or anything like
Yeah,
that?
it was notarized with witnesses.
Now, is it customary in the state of New Jersey for the trustor and the trustee to both sign the document?
Yes,
Would that be the way that you would do it?
absolutely.
Okay. Now, this trust, did you determine whether or not it had beneficiaries?
Yes.
And who were the beneficiaries?
It was Jennifer Carides, which was the future wife, and any future children of the marriage.
Okay. So based upon your review of this document created in 1999, was Keith Caneiro married at this time?
He was not at the time of drafting, no.
And were you able to tell that based upon reading the draft alone?
Yes, there's a requirement that for Jennifer to qualify as a beneficiary, she would have to marry him within, I think, 2 years. It was 2001 or something.
Okay, and was there specifically a date in the document that's listed?
Yeah, there was a date in the document.
And is it your understanding, just based upon the minimal information provided, that they did get married?
It is my understanding they did ultimately fulfill that requirement, yes.
And I think, just to be clear, based upon what you said, at the time that Keith Caneiro created the document with counsel, he was not married, correct?
Correct.
And did he or did he not have children yet?
It did not at the time.
Does the trust agreement, I think you said it, but does it contemplate future children?
Yes.
And are those future children listed as potential beneficiaries?
Absolutely.
Now, are there, with respect to Jennifer, eventually to be Jennifer Caneiro, and eventually to be the children, is there any reference to the children's issue or anything along those lines?
So Jennifer did have a requirement to be married and not divorced, because if she was divorced, she would also be disinherited. But the children were always contemplated even before they existed.
How about the children's children?
Yeah, I believe there is a section there that it covers where if it says per stirpes, which means that if one of the children were dead but they had children, that they would inherit as well.
Now, with respect to your review of this trust, did you kind of come up with like an overall theme based upon a reading of the document as to the settler's intent?
Yes, it was clear from the drafting that he intended to benefit his wife, but definitely his children that didn't exist at the time, but he intended for his children to be definitely benefit by this trust. There was no conditions for the children. that he would have to take from this trust.
Okay. Were there contingent beneficiaries?
There were.
Okay, what is a contingent beneficiary?
A contingent beneficiary takes, based on a trigger set in the drafting of the trust. So something has to happen for that person to take this, after the primaries.
And who are those people?
So that's Corey Caneiro and Paul Caneiro are the alternate beneficiaries.
Okay, so Paul Caneiro and Corey Caneiro.
Yes.
Were they 50-50 contingent beneficiaries or something else?
They are 50-50.
Now, assuming that Mr. Caneiro married Jennifer Caneiro and they had 2 children, if Keith Caneiro were to pass away, who would benefit?
The widow and the children.
How would, under this trust agreement, how would contingent beneficiaries, Paul and Corey Caneiro, how would they benefit?
The only time they would benefit from the trust would be if, or the children and the widow would also be deceased.
Now, with respect to that trust agreement, which is in front of you, S-26. I'm going to ask you to go to page 5. Can you do that? And is there Article 4 there?
Yes.
And what does that discuss?
It discusses the death of the settler
Okay.
and who would take.
Now, are there provisions that start on page 6 regarding what you just discussed about contingent beneficiaries?
Yes,
Is that subsection A and subsection B?
correct.
Okay. Can we have the back computer, please? Now, on the screen in front of you, is that subsection A and B that you just referred to?
Yes.
Okay. And subsection A talks about what?
It talks about what Paul will receive if the spouse and the children do not survive.
Okay. And subsection B?
It talks about Corey's 50%.
Okay. And to be clear, subsection A, subsection B, one relates to Paul, one relates to Corey, correct?
Correct.
And are they otherwise identical, essentially?
Yes,
Okay.
essentially.
So they're 50-50, correct?
Yes.
Now, as a contingent beneficiary, did Corey Caneiro sign this document?
No, beneficiaries usually don't.
Did Jennifer Caneiro sign it?
No,
And obviously the kids didn't because they weren't born yet, right?
correct.
What do you think? Now, I think at some point you were provided with information that strike that, we just start here. What was the trust originally funded with in 1999?
The original assets in the trust was $1,000.
Okay. Did you learn later that there became a life insurance policy attached to it?
Yeah, there's some provision in the trust that allow for, life insurance policy, which is very common, or other assets to be introduced to the trust or transferred to the trust.
What types of other assets can be attached to a trust?
It could be bank accounts, could be real estate, could be cars, could be any asset that they want to transfer.
Now, we talked about earlier, but this was an irrevocable trust, correct?
Correct.
Now, you talk generally about, I think, asset protection in the trust context.
Yes.
Can you just tell us how that works or is supposed to work?
So, in an irrevocable trust, once you transfer the assets, they're protected from creditors, they're protected from bankruptcy, they're protected from lawsuits. So that would have protected Keith from that. This trust also protects the beneficiaries from that as well. There's a spendthrift clause that does that.
What's a spendthrift clause?
It's a clause that you typically put in trust that does not allow the beneficiaries to be sued for future benefits that they might receive from the trust. So they don't have that, what's in the trust, they can't pledge that for future, so they can't be sued under that for the benefit they have for the trust, on the trust.
Now, ultimately, the property that's covered by the trust agreement, if someone passes away, does it become part of taxable estate at that point?
It does not.
Okay, and is that part of the point of creating a trust?
That is part of it, yes.
Now, that specific idea, is that codified in the IRS code?
Yes,
So that's just part of laws here in the United States.
yes.
Now, going back to like 1999, obviously you were not there when this trust was created, correct?
Correct.
Now, but are you able to tell us, once Keith Caneiro created this irrevocable trust, what happens?
So once he created it, there was an insurance policy. I understand he also created at some point after that was the beneficiary was the trust, and he was through this trust. There was a bank account as well that was he was putting money into to pay for that the fees for the life insurance.
So there's a bank account that's designed to fund the life insurance.
Yes, it's attached to the trust.
You weren't asked to look at the life insurance, though, correct?
I did not look at the life insurance, no.
Now, as far as Keith Caneiro's control of the trust once it's created, how does that work?
He does not maintain any control over the assets in the trust or the trust itself. He relinquishes all control to the trustee,
And the trustee being who?
Paul.
Now, we mentioned it briefly, but if Keith Caneiro or any trustee in a document like this, irrevocable trust, decides that he wants to change the trustee, how does that work?
The only people who have power to change the trustee in an irrevocable trust are the beneficiaries. So the beneficiaries could either request for the trustee to step down and name someone else. There was a provision in there. Or go to court and have a judge remove the trustee.
But a trustee can decide, okay, I'll step down?
Yes, there was a provision in this trust for that as well. And Corey would have been the alternate.
Okay. As far as trustee powers and responsibilities within the Keith Caneiro irrevocable trust agreement, can you describe that?
Yes, I mean, the trustee in this trust had wide latitude, a lot of power and a lot of leeway. It was drafted with that in mind, no question about it.
So it grants the trustee, Paul Caneiro, broad powers under
Broad
the trust.
powers, yes.
Now, with the idea that the trustee has exceptionally broad powers, is there any sort of flip side to that?
Yes, I mean, the trustee's primary responsibility is to manage the assets in the trust for the benefit of the beneficiaries. That's the top priority. But as more latitude and more broad powers are given to that trustee, that responsibility increases as well.
Power, responsibility kind of thing?
Yes.
Now, administrative powers to the trustee in this trust, are they discussed?
Yes.
Okay, and what types of things are discussed in that regard?
Well, they have the power to hire professionals like accountants, make sure they file taxes, make sure they can hire financial advisors if there was accounts there that needed that, attorneys if they needed to do any modifications. So there's wide latitude.
Okay, so the trustee can hire qualified professionals for advice and things like that?
Yes.
Now, I'm not saying that happened, but if it were to happen, who pays for that?
Typically, the trust would have some funding for that, but it would be the trust money would be used for that.
Okay. So it wouldn't have to come out of the trustee's pocket?
No.
Now, under the terms of this trust agreement and potentially others, is the trustee entitled to compensation?
Yes.
Okay, is that discussed specifically in the trust agreement?
Yeah, there is a paragraph that talks about that. It leaves it up to the statute. There's a New Jersey statute that defines trustee compensation.
Okay. Is that a statute that you're familiar with?
Yes.
Is that something that you use in your daily practice?
Yes.
Okay. Can I just draw your attention to page 10 of the trust agreement, S-26? Is there an area there that talks about compensation of trustee?
Yes.
Okay. Is that something that you discussed in your report?
Yes.
Can I just go to the back computer again? Sorry. Now, on the screen in front of you, do you see that provision for compensation of trustee?
I do.
Okay. And can you just tell us what that actually means?
It means that the settlor did contemplate the trustee being compensated for his work as a trustee, and that he left it up to the laws of New Jersey, which would fall on the statute to define what that compensation is.
Okay. Is there another, a little bit more specific provision that's discussed regarding compensation or the potential for compensation? You recall?
As to the requirement if they receive the compensations, or?
Sure.
Yes, I mean, there's another section that talks about what's required if the trustee receives any funds from the trust.
Okay. Just going to show you that trust agreement for one moment. You're on page 10. I'm going to ask you, sorry, I just shot you.
That's right.
Yep. Okay, so page 11, I'm going to draw your attention to subsection J. Just, if you could just read it to yourself. And does that refresh your recollection as to potential other mentions of compensation?
Yeah, it just mentions that, reserve funds to pay for any expenses, including compensation of the trustee.
Okay.
Yes.
Now, is trustee compensation, is it defined or like mathematically in any way in New Jersey statutes?
Yeah, the statute does have a formula for compensation, and it's a percentage of the corpus or the income.
Okay. Now, how is compensation balanced with, the context of fiduciary obligations to beneficiaries in a trust?
Compensation, it could be reduced from what the formula or the statute says, depending on the level of involvement of the trustee. If the trustee does all the work himself, he's doing the taxes, doing the investment, doing the research, and investing and managing the assets himself or herself, then they might require a higher level of compensation. If they are hiring professionals, attorneys, or CPAs, then that compensation could be reduced because they're not using their own expertise, they're using someone else and using trust funds to pay for that.
Now,
So it could be flexible.
under New Jersey statutes relating to this type of procedures, does compensation have to be reasonable?
Yes.
Okay. Now, how's reasonableness defined generally?
Well, reasonable is depending on the level of involvement you have in the trust. The statute does have percentages, so it's a mathematical formula. But within that mathematical formula, there is leeway to take more, not more than the statute says, but more up to the statute number or less if they're hiring other professionals.
Does compensation that is taken or received by a trustee, does it have to be transparent?
Yes, the trustee has a duty to inform, and this trust has a provision for that, the beneficiaries of any monies that is dispersed to him or her.
So does any compensation have to be disclosed to the beneficiaries?
Yes.
Just going to draw your attention to page 3, section 2.3C of the trust.
Yes.
Do you see that provision?
Yes.
And what does that discuss?
It discuss, written notice actually, but at least notice to the beneficiaries of any transfer or property to the trustee.
And is there a specific section, you don't need to point it out specifically, but is there a specific section in the trust regarding notice?
Yes.
Now, you mentioned it a little bit earlier, but is there a section of your report that talks about power and responsibility?
Yes, there is.
And you talked about how extensive powers create high standards for trustee performance.
Yes.
Now, can you talk about what these high standards would mean? What does the trustee have to do?
Yeah, the trustee has various duties when they manage the trust. They have a duty of transparency with the beneficiaries. They have a duty to not commingle funds with their own. They have a duty to act in the best interest of the beneficiaries. They have a duty to be cautious and be careful with the assets and protect the assets for the beneficiaries. That's the primary purpose of the trustee.
We have competence, good faith, things like that.
Yeah, they have to act in good faith.
Okay. Be transparent.
And be transparent, inform the beneficiary of what's going on, yes.
Now, we talked about discretionary powers of the trustee, right?
Yes.
Does that also have limits?
Yes, under the trust, the trustee has limitations, correct?
I think you mentioned previously terms like loyalty and prudence.
Yep.
And good faith.
Yes.
Now, I want to ask you about fiduciary duties of a trustee. Are there 4 fiduciary principles that govern the laws in the state of New Jersey?
Yes.
Okay. And do you recall the ones that you discussed in your report?
Yes, they have a duty to treat the trust assets with prudency, make sure their investments are sound, that they research it, make sure that any transfer of assets is proper and it doesn't go against the trust language or the intent of the trustor when it was created. So their job is to act and manage the trust assets in a prudent way, in a transparent way that protects those assets. That's in good faith.
You talked about loyalty previously, correct?
Yes.
Now, are there things that the duty of loyalty prohibits?
Yeah, it prohibits the trustee from using trust funds for his or her own benefit.
Now, are there any provisions in this trust where a trustee could use trust assets for their own benefit if they actually did something to get that okay.
Yes, I believe on the distrust and the amount of leeway and flexibility that it offered, the trustee could have informed the beneficiaries if he wanted to use funds from the trust, such as a loan or just plain use it, yes.
Okay, but that requires the assent or permission of whom?
Of the trust, of the beneficiaries.
That would be whom in this case?
In this case, it would be the spouse, because the children were minor and under her care. I think only the spouse would have sufficed.
Does the trust agreement, does it discuss avoiding conflicts of interest?
Yes,
And I think you just talked about self-dealing, correct?
correct.
Can a trustee benefit personally from the trust?
No, not other than the customary fee, that statute fee.
Now, we talk about conflicts of interest and the like. Is there a section in the trust called trustee restriction? You
Yes,
recall?
there is.
I just want to draw your attention to page 10 of the trust, section 6.2. Do you see that there, sir?
Yes,
And have you reviewed it?
yes.
Did you discuss that in your report that you drafted?
Yeah, this allows the trustee to distribute income or make payments from the income or principal for the beneficiaries, but not to himself or herself.
So self-dealing in some regard?
Self-dealing, yes, so using the trust funds for his own benefit.
Yeah, I think, I'm not going to go back to it, but I think you discussed page 3, section C of the trust agreement as well, correct? Providing prompt written notice to the beneficiaries?
Yes,
Okay. Is that consistent with this principle regarding trustee restrictions?
yes,
Can a trustee participate in decisions to distribute trust property to himself?
I think on the distrust, he could participate in that decision, but there was a requirement to disclose to the beneficiaries that action.
Okay. Now, recall discussing in the report administrative responsibilities of the trustee.
Yes,
And did these, let me just refer you to page 10 of the trust, if I could. Do you see that, sir, that page?
yes,
And we talked about trustee restriction already, correct?
yes,
We talked about compensation.
yes.
And there's something in there about accounting. What does that represent?
So typically, a trustee is required, or at least should, on a yearly basis or a regular basis, doesn't have to be yearly, but on a regular basis, depending on the assets in the trust and how much they change, to provide the beneficiaries with an accounting of the trust and what has transpired in that trust during that period of time. Could be every 6 months, every year and a half, but in a regular basis to provide that update to the beneficiaries.
Does this trust and trust law generally, does it talk about tax compliance?
Yes, there's a section about taxes.
And what does that mean?
So the trust requires that taxes be filed if there was income in the trust on a yearly basis.
And who would be responsible for that?
The trustee.
Now, as far as accounting and disclosure, is that something that's discussed specifically in this trust agreement?
Yes.
Okay, and what does that require under this trust?
It requires in the accounting section, it requires for the trustee to maintain accurate records. It requires for them to make sure they're compliant with the federal and state taxes that they're filed if required. It requires for them to provide the accounting, as I mentioned before, to the beneficiaries. And on the disclosure, it requires these actions be disclosed to the beneficiaries on a regular basis.
Does that include like receipts and financial documents and things like that?
It could include that. I don't know that they need to go to that extent for the beneficiaries, but at least a high-level accounting of what is going in and out of the trust.
So could that include like an accountant that's hired to actually do the taxes for the trust?
Yes.
Would this trust require that the records provided to an accountant or to the beneficiaries, that they be accurate?
Yes.
Now, obviously this trust involves family members, correct?
Yes.
Okay, so we got Keith Caneiro and his brother Paul Caneiro being the trustee, right?
Correct.
Now, does the law in the state of New Jersey regarding, trust requirements and the like, does it do anything to heighten restrictions and or powers or anything along those lines because there's a relation there?
Yes. I mean, I think when courts look at trust matters that come before them, they usually place a higher level of responsibility on trustees that are close family relatives or members, because the courts usually say that, or interpret it in a way that says that close family members know family dynamic, they know the ins and out of families, they know if there are beefs between people, if people are getting along with each other. They have an internal knowledge that a corporate or an external trustee wouldn't have that knowledge of. So they know that they can use that as trustee as well.
Okay, so I think everyone could understand we have a trust and a trustee and they're related here, right?
Yes.
Are there ways, are there people or institutions that can be appointed as a trustee that takes away that family dynamic?
Yes, typically. Yeah, I mean, people sometimes appoint friends, their attorney. I think Bank of America has a branch. So several other institutions can be appointed as trustees, yes.
And that Bank of America idea that you're entrusting a financial institution to manage the trust.
Correct.
Takes away family dynamic, correct?
Yes.
But it also loses that family dynamic, right?
Yes, and it loses a lot of the internal controls that are kept when it's kept in family.
Now, you may have mentioned it, but did you talk about trust property and segregation requirements in your report?
I did talk about that.
Is that something that's based on plain reading of this trust?
Yes, it's obvious. There's a paragraph somewhere that talks about not commingling assets, personal assets of the trustee with trust assets.
Okay, so keeping separate personal assets and trust assets.
Correct.
That's in this trust?
Yes.
And is that a concept in New Jersey law?
It is a concept in New Jersey law, and that assets should be kept separate. All money or any assets should be kept separate. The trustee own assets from the trust assets should not be commingled. Bank accounts or any other asset.
Okay. I think you mentioned loans before, correct?
Yes.
Okay. We talk about loans from the trust to the trustee and whether those are permissible. Can you explain?
Under this trust, I believe that there was enough, there was some broad of discretion that they were permissible. If the trustee wanted to get a loan, I think he could have as the beneficiaries for it, yes.
So, in this document, it's your reading of it that there is a potential that the trustee could take a loan from the trust.
Yes, if there were funds in the trust, there's potential there, yes.
But it would require him to ask permission, correct?
Yes.
Now, you talk about, towards the end, misappropriation. Can you tell us what that means?
That is using trust funds for a purpose that wasn't intended and using the powers of the trustee to do that.
I'm not asking for you to opine about anything other than the question of can misappropriation constitute theft? Can it?
It could.
Now, is there like an intent requirement that would transpose misappropriation to theft?
Yes, I mean, it would have to be an intentional act.
Now, talk about using trust funds for unauthorized purposes. Could you just tell us what that would include?
That would include, in this trust in particular, any use of funds from the trust or any use of the assets in the trust that would benefit anyone else but the beneficiaries.
Would that include personal living expenses?
That would definitely include personal living expenses that are not paid to the beneficiaries.
When we talk about bad faith or deceptive practices in your report, would editing or altering records relating to the trust be a breach there?
Yes, if done for the purpose of hiding some misuse of funds, yes, or property.
Now, almost done here. Just a couple more questions. Now, to be clear, I think you've testified that the trustee, Mr. Paul Caneiro, in this case, was given broad powers under this trust. Fair?
Fair.
Now, but with those broad powers, you discussed limitations, correct?
Yes.
And those limitations generally are what? Are they the laws of the state of New Jersey, the trust language itself, or both?
They're both. They're in the trust language, and there are also statutes to that effect.
You talked about fiduciary obligations, correct?
Yes.
Is that a requirement to act according to fiduciary duties of trustees generally and what's in this trust?
Yes.
Does the trustee have to act in good faith?
Yes.
Do they have to be transparent?
Yes.
Do they have to act with loyalty to the beneficiaries?
Yes.
Because that's really what it's about, right? The beneficiaries.
That is 100% what it's about. Yes.
So when Keith Caneiro gave Paul Caneiro the authority to be the trustee of this trust, it really wasn't about Keith Caneiro, correct?
Objection. This witness doesn't know what it was about.
To rephrase.
Yeah, rephrase the question. Sustained.
Legally, from a legal concept and based upon a fair reading of the trust, did Keith Caneiro's thoughts matter anymore at that point?
When the trust was created,
Sure.
yes. I think I talked to this. The main intent of Keith, from my reading of the trust, was to benefit his children. And obviously, his wife, should she married him. But even if she didn't marry him and he had children, those children would have been covered under this trust, not necessarily Jennifer.
Because you mentioned there's like there's some divorce language in there, correct?
Yes.
But again, the trustee's obligations in this trust and any trust extend to who?
To the beneficiaries.
I have no further questions.
Ross?
Thank you. Morning, Mr. Cardenas.
Good morning.
So, during the voir dire component of your testimony, you mentioned how even though you're an attorney working in trust and estates law on a very regular basis, you still bring in other professionals to help assist you and your clients in your work, right?
Yes,
And that would include tax professionals, right, and CPAs.
that's correct, because I'm not qualified for tax advice.
This is a pretty complicated area of law, right?
Yes,
I mean, it involves issues about probate, about contracts, about tax. All these different areas kind of converge when we're talking about trust and estate planning, right?
yes,
So even though you're a legal expert, that may not be enough to fully advise and inform your clients about what is in their best interest.
as it relates to trust drafting, yes. As it relates to how to maximize tax savings, probably not. That's why we bring in other professionals.
I think the point I'm trying to make is just that this is complicated, right?
Yes,
And to be a trustee, a person does not need to be a lawyer, right?
there's no qualification for a trustee.
There's no requirement that they be an accountant or have a finance background, right?
Correct,
There's no requirement that they take a test to demonstrate that they're qualified to be a trustee, right?
correct,
There is no assessment to confirm that they are aware of the applicable laws of the state of New Jersey regarding trust administration, right?
correct.
There's, a person doesn't need to know or demonstrate they know New Jersey law or anything about the Uniform Trust Code to be a trustee, right?
Correct.
You testified today that obviously the law places attendant fiduciary responsibilities on a person who becomes a trustee, right?
Yes,
And they need to avoid engaging in things like self-dealing, right?
yes,
And they need to act in the interest of the beneficiaries when they act as a trustee, right?
yes,
But if there's no test to become a trustee, and there's no classes, and there's no requirements about what it takes to be a trustee, or an awareness of the law of trusts, a person doesn't even need to demonstrate that they're aware of those fiduciary responsibilities in order to become a trustee, do they?
they do not, but they also have the opportunity to turn down that position if they don't feel they're qualified or able to administer their duties.
Well, that would imply that such a person was informed about those duties at the time they became a trustee, right?
Correct.
And when we're talking about a particular trust, this particular trust, it's an obvious fact that you were not there when this was created, right?
Correct.
And you do not have any idea what conversations were had or were not had at the time of this trust creation, right?
Well, I have an idea because I'm an attorney and I do have conversations with my clients about what their duties and responsibilities are during the formation of the trust and during when they sign it and what they're signing on to. So I'm not sure the other attorney would have had similar conversations with them.
Well, you're sure about that, but the thing is, you don't know what was said.
I don't know exactly what was said.
And obviously, some attorneys, sure you would agree, do a better job of effectively keeping their clients informed about important issues than others, right?
I'm sure that's true.
And I'm sure you do very good work for your clients. But I'm sure we also know that that's not a universal truth about attorney representation, right?
I don't know what was discussed in that room, but I know most attorneys will have a discussion about it.
Well, let's talk about people who create trust as far as the settler of trust for a second. So Keith, in this case, was the settler of the trust, right?
Correct.
Because it was him creating it for the purpose of benefiting the beneficiaries.
Yes.
Now, obviously, we know that Keith went to an attorney to create this trust document, right? I mean, they're the ones who drafted it.
Yes.
And most people are going to go to attorneys for the purpose of creating something like this because, again, they don't know what the legal requirements are to do it, right?
Correct.
So most people rely on advice from their attorney when they create something like a trust, right?
Yes.
Now, I'm sure you're absolutely right that most attorneys who create a financial instrument or a trust instrument like this are going to advise their clients on the ramifications of this trust. But again, just like there were no requirements on the trustee to become a trustee, there's no requirement other than competency that the settler must meet to demonstrate they understand the full ramifications of what they're creating, right?
Yes, for the most part, that's true.
There's no classes a person has to take before they can create an irrevocable trust, right?
No.
They don't have to demonstrate knowledge about the laws of irrevocable trust in order to become a settler, right?
No.
We can talk about what attorneys would do in most situations, but like you said, we don't know specifically what conversations were had about this particular agreement, right? And so it's not possible for us to know whether Keith understood the full ramifications of what was being done when he was creating an irrevocable trust in this case, right?
It's possible, I said. So.
It would be fair to say, though, that the thing with an irrevocable trust is that the settler, the person who creates it, it's irrevocable because once it's created, they lose all control over it, right?
For the most part, that's true.
Like, they don't get to direct what happens with the money in the trust anymore.
Not the day-to-day, correct.
They can express an intent in things like the trust documents, right? To say, this is the purpose for which I'd like you to use this money, right?
Correct.
But the idea is that in an irrevocable trust, the property that gets transferred into it no longer belongs to the settler, right?
That's correct.
I mean, and that it's that kind of like legal fiction that allows this to be a device for certain tax avoidance, right?
Yes.
Because if that settler maintained control over the property in any way, there would be different tax implications for that, right?
Correct.
So what this really is, in terms of in the irrevocable nature of a trust, is it is a way to do estate planning, but also in conjunction with that, a way to do tax planning and tax avoidance, right?
It's part of it, yes.
It would be fair to say, given those facts, that a settler who created an irrevocable trust, but was under the impression that he was going to be able to direct the trustee as to what to do with the funds afterwards, would be under a misapprehension about the legal instrument he was
Judge, I'm
creating.
going to object to Keith Caneiro.
Yeah, I'm going to sustain the objection to the form of that question. It's way too much. You got to unpack it.
A settler it's established, though, that a settler of an irrevocable trust, once it's created, cannot continue to maintain control over trust assets.
That's a true statement.
And cannot, based on what we have here, direct a trustee in terms of how to disperse trust assets after the creation of the trust.
No, correct. That goes against the trust. I mean, he did direct it when he first created the trust.
Right. But after it's created and it's signed and it's in place, right, that settler no longer gets to direct the trustee as to how to disperse assets, right?
As long as the trustee is acting within the law, correct.
The trustee, and so a settler, I guess my question is this. If a settler, under those conditions, right, if a settler of an irrevocable trust was under the impression that they could continue to exercise control after the creation of the trust instrument, they would be under a misapprehension about what their abilities were.
Yes.
A settler who thought they could terminate an irrevocable trust after its creation would be mistaken about that.
Yes.
And a settler who thought they could terminate an irrevocable trust for the purpose of, say, taking the money to pay off their mortgage would be under misapprehension about the amount of control they had.
Judge, I'm going to object. Have you heard you, Kevin?
I'm going to sustain the objection to that question, but I'm going to allow counsel to ask a different question.
Thank you, Judge.
Sure.
So, we heard you say before that a trust can hold many different types of property, right?
Yes.
And it could hold, stocks, it could hold cars, it could hold, other personal property. It could also hold insurance policies, right?
Yes.
And when the trust holds an insurance policy, when it's within the trust, that's the property of the trust, right?
Yes.
So, if a settler creates an insurance policy and says, I'm going to gift this to my irrevocable trust, that insurance policy becomes the property of the trust, right?
No, not at that moment. So if the settler creates an insurance policy himself or herself and adds the trust as a beneficiary, the trust wouldn't get that policy until the settler dies. So the settler will still keep control of that policy. They can go and change the beneficiary anytime.
Well, if the trust in the insurance, if the insurance policy documents, right, wouldn't they have to be changed to reflect the fact that the insurance policy was now within the trust?
So the owner of the policy and the beneficiary of the policy do not have to be the same person or the same entity. So the trust, I didn't review the insurance policy in this particular case, but Keith could have been the owner of the policy and have the trust as the beneficiary. So he would still own and be responsible for that policy. I don't know who owned the policy in this case.
You don't know if the policy was owned by Keith originally and transferred to the trust, or if Keith owned it the entire time.
Correct.
That's what you're saying. If the policy was transferred to the trust, who would the owner of the policy be?
The trust.
So then, the beneficiary would stay the same, obviously, with the insurance policy, right?
Provided it did, yes.
But the owner would be different if that policy was transferred in ownership to the trust, is what you're saying.
Yes.
Okay. And you didn't review the insurance policy in this case?
I did not.
Okay. Now, let me just switch back for a second here. A trustee does not need to be a family member of a settler, right?
No.
There's no requirement that they be related in any way.
No. It often is, but there is no requirement.
A person could, you mentioned, retain like an independent agent to act as their trustee.
Yes.
You could hire somebody like an attorney to do it.
Yes.
I mean, if you already had an accountant who was working for you, you could maybe ask your accountant to be the trustee,
Yes.
right? A person could, obviously, if you appoint somebody with knowledge about tax or trust law, they're going to obviously bring, we would imagine, a greater deal of sophistication to the administration of the trust than just any family member, right?
They could.
Because like we talked about with trustees, like a trustee who doesn't need to meet any requirements in order to become the trustee could end up thinking that, a settler still held some level of control over an irrevocable trust, right?
It's possible.
I mean, one of the things that you mentioned was that with taking a trust outside of the family dynamic removes some of the, I think you said, internal controls that exist in family trusts, right?
Yes.
And like those internal controls are things like conversations, right, between perhaps a settlor and a trustee, right, who are also closely related,
Yes.
right? And those kind of conversations between a settlor and a trustee who are closely related might have a very different dynamic than between a settlor and an unrelated financial professional who's acting as the trustee, right?
For the most part, that would be true.
That's going to be that second one is going to be a much more arm's length kind of transaction, right?
Yes.
And so that internal control you're talking about in family trust, it serves a purpose that perhaps could not be served by taking a trust to a financial professional to administer, right? Is that true?
Possible, yes.
Okay. A family member who's acting as trustee could obviously think it was okay to borrow money from the trust and repay them.
Objection, Judge, you can't answer that.
Sustained.
You mentioned loans from the trust
Yes.
when you were testifying before. And you said that under this particular agreement, a trustee would be able to take loans, but the issue I think you raised with that was notice to beneficiaries that the trustee was doing so.
The requirement would be noticed.
Now, in this case, we do have the situation where we have a closely held family trust. The trustee is the brother of the settlor, right?
Yes.
And you knew that, as you were evaluating this, that they were also business partners for more than 2 decades?
Yes, I did know that.
Okay. And so you knew that they were constantly in communication about business dealings and whatnot, right?
I suppose there were.
And if the trustee and the settlor are in that relationship, right? And the settlor is the parent of the beneficiaries. It's reasonable to imagine that the trustee might think effective notice to the beneficiaries is beneficiary to the
Objection.
Sustained. There's a lot of speculation in there. You cannot guess that. I cannot allow you to ask that question in the form you're asking it. If you found another way to ask it, maybe I'll allow it, but not that way.
We know the settlor here, Keith, is the parent of the minor beneficiaries in the trust, right?
Yes.
And we know that notice in various respects about trust administration is required to be given to the beneficiaries, right?
Yes.
We also know that obviously minor children need to have some sort of guardian making these decisions about whether trust administration is appropriate, right?
Yes.
Because minor children are not old enough to make those determinations themselves.
Yes.
So they need a parent or a guardian to make those determinations for them, right?
Yes.
And in this case, Keith was their parent, right?
But not a beneficiary under the trust.
But Keith was their parent.
Yes.
And Keith was the parent of them as they were the beneficiaries, right? And so notice can go from a parent, from a trustee to a parent to a minor beneficiary, right?
I don't believe that's true in this case. I think the notice, it's clear that it's to the beneficiaries. There's a paragraph that talks to that. It's on the 2.3C, I believe.
Yeah.
That talks to even written notice, but let me see if I can. Yeah, 2.3C, page 3. I don't know if you want me to read it or.
I think you've read it before. That the trustee should give prompt written notice to each of the beneficiaries of each transfer of property to the trustee.
Yes.
If any beneficiary is less than 18 years of age, a copy of the notice of transfer should be given to the guardian of the beneficiary. Right?
Yes.
Okay. So, but, I mean, that implies to me, and tell me if I'm wrong, that Keith is the guardian of the beneficiaries.
Of two of them.
Right.
Yes.
And he's married at this point in time. After this is created, he's been married to the other beneficiary, Jennifer, right?
Yes. And the other guardian.
So, my point is just this. Obviously, we see language in this actual trust document, right, that talks about keeping beneficiaries informed of what's happening with the trust, right?
Yes.
What we don't as clearly see is whether keeping the settlor informed, right, could be viewed as equivalent notice based on the very closely held nature of this agreement.
There was definitely a dual role there, yes.
Now, you mentioned during your testimony earlier that trusts don't have to be extremely broad in terms of their intentions. A trust can be very specific as to how monies can be allocated and for what purposes, right?
Yes, that's true.
The Keith Caneiro Trust, you say in your report, I think you describe it as granting exceptionally broad powers to the trustee.
Yes, I did.
And that word exceptional, it's meant to mean that what this trust does is really maximizes to the full extent of what's possible legally, what the trustee can do as far as the administration of the trust.
While acting within the confines of the law and in good faith and
Right.
all the requirements of a trustee.
Sure. But all those things, right? Good faith and the fiduciary responsibilities, those things are extrinsic to the trust. They're codified in laws, right?
They're codifying laws and they're explicit in the paragraphs in the trust.
The trust itself doesn't place really a limitation on investments that the trustee can make, right?
It does not.
It doesn't tell the trustee how beneficiaries should be, or when disbursements should be made to beneficiaries, right?
Except for age. That's true.
It doesn't preclude the trustee from favoring one beneficiary over another.
It does
Right.
not.
It doesn't specify that there's certain purposes that money can be used for and certain purposes that it cannot be used for, right?
Correct.
It doesn't really give very much guidance at all in terms of how Keith would want this trust to be administered, right?
Well, I see, if you read it as a whole, the trust, Keith's intention was to benefit his children and his wife via this trust. And that was the primary intent of Keith. Given those powers, in his mind, were to be used to benefit those three people.
Well, I mean, I think that's an interpretation. The thing is, like, when Keith created this, he wasn't married yet, right?
That's correct, but there was definitely in his mind because it's part of the drafting of the trust, which is not common to put in there.
Yeah, well, let's come back to that in a second. But he wasn't, he wasn't married yet, is a fact, right?
Correct.
And it's a fact he didn't have children yet, right?
Yes, definitely.
And obviously this is a trust that, on its face, is meant to benefit his wife and future children, right?
Yes.
All of whom exist at this point contingently when the trust is created, right? The trust also, though, indicates that there's certain circumstances under which his wife Jennifer is going to be disclaimed.
Yes,
Right.
that's correct.
And it would be divorce, right?
Yes.
And it would also be if they're living separately under circumstances that would give rise to a cause of action for divorce.
Yes.
Right. So basically, if they're divorced or separated at any point in time, this instrument treats Jennifer as if she had predeceased Keith.
That is correct.
And when this was created, it was funded with $1,000, right?
Yes.
I'm sure with the intention, you'd imagine, of being funded with additional assets in the future, right?
Yeah, there's a provision in there for that.
And the idea would be all these assets go to benefit Keith's family, but if Jen divorces him or they separate, she no longer gets any of them, right?
Correct.
So, I mean, I guess I just get the sense, and I could be wrong, that if somebody came to you and said, I want to create an irrevocable trust, and I want to benefit, some future family that I don't have yet, and I don't really want to put any limitations on the trustee in terms of what they can invest in, who they can favor as far as beneficiaries, and I want to do all that, and I want to fund it with only $1,000. I wonder whether you would have advised them to create this.
Yes, I mean, again, there's a paragraph in there that, so the intent of the trustor of Keith was to fund this trust either through a life insurance policy that he did or may or may not have had at the time, I don't know that fact, but through a life insurance policy or other assets. So creating an instrument to have it ready to fund at a later date is not uncommon.
Is there any way to look at this as kind of a de facto prenuptial agreement?
No, the only thing that is there, because no, there isn't. Because the only thing that the spouse would not be entitled to is the assets in the trust. There's nothing outside of the trust that the spouse wouldn't be entitled to that I'm aware of.
I hear you, but when this was created, there was only $1,000 in the trust, right? And when it was created in 1999, we didn't know what was going to be put or not put into the trust, right?
We don't. We have an idea, but we don't know for a fact what, people sometimes create a trust and may not be able to fund it depending on their financial situation, but
So, well, let's just talk about the actual administration of this trust. So you're aware, obviously, that Keith and Paul owned businesses together, right?
yes, I'm at a very high level. I'm aware of that. Yes,
Okay. Like you don't have the financial records from the businesses or anything like that.
or the knowledge of the actual business or any of that.
Okay. But the trust, if you know also though that like there's this insurance policy and then there's a trust account, right, for the trust.
Yes, typically that people do that.
And that the trust account in this case was used to pay premiums to the insurance policy.
Yes.
And would it be correct to say that transfers, like that there shouldn't be transfers from the trust account to the business account held by Keith and Paul?
Objection, Judge. This has nothing to do with his testimony at all.
Can we come in? Ladies and gentlemen, I'm going to sustain the objection. You guys were smiling. I make you laugh. You can't give me one right back to me? Nothing? All right, that's fair. That's fair. All right, so what we're going to do is we're going to take our 15-minute break. Why don't you go in, take a break, do what you need to do. If you're running 5 minutes behind, we got you. But otherwise, we'll be back out somewhere in the area of 10:25, 10:30. Thank you. Okay, we'll continue with the cross-examination. Mr. Murray.
Thank you. Okay, Mr. Cardenas, I think we left off talking about family trusts and settlers and trustees who are closely related. I take it just very broadly that the implication of this irrevocable trust is obviously that the settler, in terms of any property put into the trust itself, that the settler should not thereafter be using that property for their own purposes.
That's correct.
Okay. What if the settler though is the parent of beneficiaries of the trust?
So the beneficiaries of the trust will still be entitled to trust property as per the language of the trust, but not to benefit their parent per se or their guardian.
Is there a way that the settler could access funds for the benefit of the children who are beneficiaries?
There's a way the beneficiary can access it, school, medical, college.
All right, so it sounds like you're saying the settler really can't have any kind of hands on the property once it goes into the trust.
For the irrevocable trust like this one, correct?
Right. And the reason why, again, is because of the tax implications of them coming into possession of that property, right?
That is one reason, yes.
But obviously, there's no, just because something goes into a trust, it doesn't mean like a force field comes up around it that prevents the settler from ever touching or accessing it, right?
There's a legal field that comes up and prevents that.
Sure, but the legal field is just a fiction of our society. It's not a physical barrier that the settler has to cross to get the money, right?
Correct.
I mean, one of the things you were talking about with family trusts is that there's internal controls, right? And one of the things about internal controls is they can allow settlers to work with trustees to control funds that on paper they no longer have access to, right?
Not legally, but I suppose there could be conversations.
No, it's not that it's legal, right? It's that a thing that people might do with a closely held family trust, right?
Possible, I guess.
It's possible, you guess, and it's probably something that you've heard about before or seen before, right?
Sustained. That question had a lot in it. You can ask it a different way, again, but that one was a little too much.
You wouldn't advise your clients to act in a fashion that was illegal, right?
No.
But that doesn't mean that people in these kind of situations might not enter into such agreements between settlers and trustees, right?
I have no idea what could have happened.
Now, is the trustee of this trust personally responsible for financing the trust account?
No.
And you understand, of course, that the purpose of the trust account itself was to pay the life insurance premiums on the insurance policy, right?
I understand that was one of the purposes, yes.
And other than that $1,000 we talked about that was made part of the trust property at the beginning of the creation of the trust, are you aware that there were, in terms of insurance policies, stocks, tangible property, are you aware that there were other things in the trust other than the insurance policy?
I am not.
Okay. So, if the kind of de facto purpose of the trust account, given it the only asset is the insurance policy, is to pay the premiums on that policy, does the trustee have an obligation to go out of pocket to pay the insurance premiums if the trust account was underfunded to do so?
No.
If there were times that the trust account was underfunded to adequately pay the insurance premiums, would there be any legal requirement on the trustee to personally pay the premiums?
No.
Now, a trustee could, if they chose, pay insurance premiums from their own personal bank account, right?
It wouldn't be advisable, but they could.
It wouldn't be a breach of the trust to do so, right?
I would consider that commingling of funds. So unless they're informing the beneficiaries that they're doing this and, being as a loan to the trust, which would be uncommon, yes, I would consider that to be a breach. Even benefiting the trust could be a breach.
Well, benefiting the trust can be a breach, but beneficiaries can acquiesce to breaches of the trust, by the trustee, right?
If done with transparency and yes,
Yeah, I mean, with transparency,
it wouldn't be a breach.
it would be a breach, but beneficiaries can agree to things that might otherwise be considered a breach of the trust.
Well, there wouldn't be a breach if the beneficiaries are consenting to it or are informed about it.
Sure. But if there is knowledge, right, and the beneficiary has the capacity and consents to conduct constituting the breach, that releases the trustee from liability for the breach, right?
Again, it wouldn't be a breach. It would just be an action that the trustee took in the best interest of the beneficiaries.
Okay.
Just be heard for one moment, Judge.
Okay, there was no specific objection, so nothing to rule on. Mr. Murray, go ahead.
Thank you, Judge. Are you familiar with New Jersey Statute 3B:31-78 entitled Consent, Release, or Ratification by Beneficiary?
I've read it before, yes.
Okay. And you know it says a trustee is not liable to a beneficiary for breach of trust if the beneficiary, while having capacity, consented to the conduct constituting the breach, released the trustee from liability for the breach, or ratified transactions constituting the breach. Right.
That provided that the beneficiary was informed and they consented to it.
Right, yeah. What it implies actually is that there is a breach. There are ways a trustee can breach obligations, right? But released from liability for doing so by a beneficiary.
That's correct.
Right? It doesn't mean there was never a breach. It means that the breach, having taken place under certain circumstances, does not constitute liability for the trustee.
It's an act that goes against the trust, but the trustee acquiesced to or agreed to.
Right. And a trustee, and the beneficiary, you mean acquiesced to it, right?
Correct.
Okay. And the beneficiary can be a child, right? And a child can't acquiesce to breach, right?
Correct.
But a parent can.
Correct. The
On their behalf.
Guardian or parent.
Right.
Yes.
You mentioned previously that when you're creating a trust document, you would want the settlor to be present and any trustees to be present, right?
Yes, at least the primary trustee.
And you're going to want the trust document to be signed by the settlor and the primary trustee.
Yes.
And you're going to want their signatures on that trust to be witnessed by someone.
2 witnesses and a notary.
And a notary, the purpose of the notary is that the notary has a seal that they can place on the document, right?
No, their purpose is to verify that the person signing is not under duress. It's that it's the actual person signing that document.
Right, right. But that's why they put their stamp on it, to say, I looked at this, I'm a licensed notary in the state of New Jersey, and this is on the level. There's nothing suspicious going on here,
Yes.
right? And that way, when you have that seal, and when you have that notary signature, we can know that those things that you'd be worried about actually took place, right? That the person who signed it was actually the person whose signature purports to be, right? And that, yes?
Yes?
And that they were not doing it under duress, right?
Yes.
Okay.
So the witnesses.
And the witnesses, but you mentioned that particularly in reference to the notary, right?
So the notary verifies the signature is the person that signed it.
Right. And this trust that you've reviewed is not notarized.
There's no notary there now. At least in the copy I have in front of me. Correct.
It's signed in the presence of 2 people, right?
Yes.
We don't know who they are.
Could be anyone that they chose to be a witness.
But below them, when you sign something, right, you're going to put your name and then put attorney of law in the state of New Jersey, right?
Yes.
Then we know you're an attorney. And if a notary signs something, they're going to put notary of the state of New Jersey and when their commission expires, right?
Yes, that's correct.
These people didn't put anything under their signature.
They did not, other than witnesses.
And this trust document does not explain who these people are.
They don't have to be related to the person, they just could be anyone. Typically, attorneys use their admins or someone in their office for that.
Yeah, right, but do you know, you're saying typically again, or usually, but like, do you know if these people were employees of this law firm? Or do you know if there's some other people?
I don't know there.
So, just showing you S26. I'm going to approach John.
You can.
You have a copy? Okay. So if we turn to page 14, right?
Yes.
I'd like to just publish page 14.
It's a part of S26.
It is. Okay. Now, let me just get the page number on there as well. Okay, so we're looking at page 14 of S26.
Yes.
We see at the bottom of the document, we see 4 signatures, right?
Correct.
The 2 people who we don't know who they are, one person whose signature purports to be Keith Caneiro, right?
Correct.
And one signature who purports to be Paul Caneiro, right?
Correct.
Now, obviously, we don't see that notary stamp on this document, right?
Correct.
And we don't see a signature from anybody describing themselves as a notary on this document, right?
Correct.
And so that purpose of a notary being present to make sure the people signing are who they say they are, we don't know if a person like that was even at this event, do we?
Not,
The answer has to be
there's
yes
no
or
notary, right?
There's no notary.
Right.
So we don't know if a person who was capable of doing those things was at this event, right?
Correct.
And obviously, you and everybody else in this room, we weren't there either, right?
That's correct.
So once again, we don't know what happened with the creation of this document, right?
We don't.
All right, thank you. Just to circle back to one thing that we were talking about before. We were talking about whether the trust was the owner of the insurance policy or whether it's possible that Keith could have retained ownership of the policy.
Yes.
If the policy documents, such as the annual reports from the insurance policy, were being sent care of Paul Caneiro, trustee, Keith Caneiro, irrevocable trust, dated July 27th, 1999. That would be an indication that the insurance policy was held by the trust, right?
Yes.
And that would mean that the policy was the property of the trust rather than Keith Caneiro, right?
Yes.
And therefore, Keith would no longer be able to control the insurance policy.
That's correct. He wouldn't be able to alter it or take it out of the trust.
And that altering it or taking it out of the trust would include, and that would also include doing things like cashing out the cash value of the policy.
That's correct. The
He wouldn't
cash
be able to-
value will go to the trust.
He wouldn't be able to do that, right?
He wouldn't be able to.
There are ways to assign administrative duties regarding trust activities without changing a trustee, right?
Yes, the trustee can hire professionals to do administrative duties.
Well, like in a closely held family trust, one thing that people could do, right, is Keith could have Paul be the trustee, right? And he could have his wife, Jennifer, be responsible for administrative duties like mailing checks to the insurance company, right?
I suppose that's true.
Like there'd be nothing to prohibit that from happening, right?
Nothing's stopping it now.
And so the insurance company, they're not going to care, right, who they're getting the check from. They just want to make sure they're getting the quarterly premiums on the policy, right?
Right.
And you don't have to be the trustee to pay the premiums on the policy. Like you said, those responsibilities, those admin responsibilities, can be farmed out to others, right?
The actual act of sending the check.
Yeah.
Sure.
Right. And if a trustee wanted to make another person responsible for giving notice to beneficiaries, they could do that as well.
Yes.
Now, there is a thing in New Jersey, and probably elsewhere, I'm sure, that is sort of colloquially referred to as a Slayer statute, right?
Yes.
And how does that statute operate?
Judge. It's so beyond the scope of direct, it's so beyond the scope of anything discussed. It's, I don't even know what to describe. Come on up.
So we know from the trust document itself that Paul and Corey were equivalent beneficiaries, right?
No alternate beneficiaries. Yes.
And
Did you say alternate?
Yes.
What's the difference?
So the primary beneficiaries are the ones that are by default inherit through the trust.
I see what you're saying. So only in the alternative, that's what you mean. Okay, I just want to make sure I didn't, you were saying something about Corey and Paul being alternatives.
No.
Okay, that was my confusion, my fault.
Thank you.
Sorry.
No
You guys
problem.
are probably smarter than me. That's fine.
but in that alternative scenario, Paul and Corey were equivalent beneficiaries.
Yes, they were 50-50.
They were 50-50. Meaning, in that alternative scenario, half would go to Paul and half would go to Corey, right?
If none of the beneficiaries were alive, or in this case, I guess divorced.
Now, there's a section of the New Jersey statutes, 3B:7-1.1, and it's titled Effective Intentional Killing on Intestate Succession. You're familiar with that?
Yes.
And what is the purpose of that statute?
Purpose is to prevent someone from benefiting who have committed a killing to benefit themselves from that, to inherit.
So essentially, an individual who's responsible for an intentional killing under this statute would be disclaimed from any testamentary gifts or any trust proceeds or anything like that, right?
That's true.
Okay. Okay, thank you. I have nothing further.
Great, thank you. Correct?
You were just asked about that statute, Mr. Cardenas, correct?
Yes.
I just want to make sure I understand. If Paul Caneiro, over here, he's convicted of killing Keith Caneiro, he can't get any of this money, correct?
No, it would go to the wife and kids.
But assuming, because in order for him to benefit at all, they all have to be dead, correct?
That's correct.
It's the only way that Paul Caneiro can benefit is if Keith Caneiro's dead, right? Right?
Yes.
Jennifer's dead,
Yes.
Sophia's dead,
Yes.
and Jesse's dead.
Yes.
Only way he benefits.
Yes.
But if he were to be convicted of intentionally killing Jesse, Keith, Jennifer, and Sophia, he couldn't benefit. Correct?
Correct.
I mean, makes sense, right?
Yes.
Now, you were asked some questions about how probate law can be complicated, correct?
Yes.
I think even the lawyers in this room can all agree. It's complicated, correct?
Yes.
Are there concepts or are there things within this trust, though, that are actually just common sense?
Objection. I don't, it's just, it's not an...
I'll ask you, you can ask that question differently. I'll sustain it just to the form. Go ahead.
Is taking money that doesn't belong to you, is that common sense?
Objection. Why would we need an expert to answer a question like that?
Are there layman's terms within the trust that anyone would be able to define and know?
Yes. I mean, I think there are good faith and acting in the best interest are terms that most people would say what is good faith, and it's doing things that are consistent with the intent of the person who asked you to do it.
Okay. I guess the question that I'm asking, and again, I'm only trying to make sure that the record is clear of what we're trying to get to here. From S26, the actual trust,
Yes.
are the words in the trust of are there words in the trust of average meaning that they mean what they mean?
There are some technical terms, but there are some areas where there are, meaning what they mean. Yes.
Okay. And are there areas within the trust that define the terms?
Yes, there's the definitions area.
Okay. But there's also, when we talk about statutes, that a trustee or a settler would have to abide by, those statutes are not located within the trust.
They are not located within the trust.
Okay. Mr. Decker, I don't know if I went too far, but I'm going to allow both of you to ask any questions based upon what I just asked, even if it's outside the redirect. Mr. Murray, I'll give you the opportunity for that. But Mr. Decker, go ahead.
Judge, I don't have any further questions.
Okay, Mr. Murray, considering I asked a couple questions, just I'm hoping to be helpful to the jury. Whatever you need to do is up to you.
All right, thank you, Judge. So, I want to ask, also that obviously this, just based on Mr. Decker's questions to you at the end there, obviously that FLAIR statute, the purpose of it is to make sure that a person who commits an intentional killing doesn't benefit in any way from a testamentary gift they would have otherwise been entitled to, right?
Correct, from those actions that he took to benefit.
Right. And that would include that the potential benefit that they could have to their family if they had been in that line of succession.
Yeah, it
right?
cuts off.
It cuts off that line of succession totally,
Yes.
right? Not just the killer, but the relations of the killer that otherwise benefit.
Correct.
And you said that there was a definition section of this
I think
trust?
there's a couple of areas where they have definitions as to what it means.
Okay.
Um,
But you're not
it's
saying
very-
there's a definition section?
No, there is no definition section, but they,
There's no section where technical terms in this trust are further defined for those people, right?
there isn't a definition section, correct?
Okay.
But there are areas where they define different terms.
Do you believe that things like good faith and whether or not good faith was present in a transaction, right? Those are things that are argued over by attorneys in courts, right? Right?
Yes,
I mean, they are, and so
in a legal
and to-
context.
Sure, but like attorneys on opposing sides can both have reasonable, meritorious arguments about whether good faith was present or not present in a particular situation, right?
Yes, in a legal context.
And that happens every day, right?
Of course.
Because sometimes things are not bright line rules, but as with many, many things in life, they are often existing in areas of gray, right?
For the most part.
Okay. Thank you.
Mr. Murray, you're all done?
Oh, I'm sorry, yes, Jeff.
Nothing else, Mr. Decker? Sir, you can step down. Thank you.
Thank you.
Appreciate your time. You can just leave everything up there. Mr. Decker will clean it up.